because I went through the submissions, my lady, and with all due respect, I didn't understand them at all. And I was hoping that I would benefit from that, but I didn't. But for the record, my lady, I completely disagree with all aspects of the Attorney General's submissions that are on record. It's a misapprehension of the terrain of public-private partnerships, the area of public-private partnerships, and a misapprehension of all aspects that have actually been included in those submissions. With respect to the submissions of my colleagues, on the question of the ruling that was cited by my counsel, I had already addressed this, but even if all the factual basis of this petition was to fall away, the issue of the constitutionality of the Public-Private Partnerships Act would still remain and would still stand. And in considering constitutionality of legislation, my lady, we do not need a factual basis. All we need is the Constitution to be able to hold the statute against the Constitution to assess whether that particular statute is constitutional. My lady, a lot has been said, but allow me to respond on the basis of the 3 issues that I submitted before this court, or actually the 4 issues. One, on the question of the exclusion of Parliament and the role of Parliament. Council says they do not indicate specifically what is the role of Parliament insofar as PPPs are concerned, which has then been infringed on or usurped by the executive. My lady, at the beginning I mentioned that PPPs are not just a procurement tool. Council seems to confuse them to be merely a procurement tool. My lady, between Article 220 and Article 223, it is very clear that expenditure and the implementation of public infrastructure in Kenya is through budgets and through appropriation by Parliament. Therefore, my lady, the question that the court ought to ask and answer is, are PPPs implemented pursuant to budgets and appropriation by Parliament? They're not. My lady, they are referred to as off-balance sheet expenditure for that particular reason. Because these projects are implemented outside the budget and they're implemented outside the Appropriation Act, the Annual Appropriation Act. There is no requirement anywhere for them to be featured in either the budget policy statement or the budgets of subsequent years, or the Appropriations Act, or even Supplementary Appropriation Act of subsequent years. And therefore, my lady, what is important is for us to be able to ask ourselves, then, does the Constitution require all expenditure to be pre-approved by Parliament? It does. A reading of Article 95, a reading of Article 96, and a reading of Article 220 all the way to 223 establishes a very clear rule that expenditure is through parliamentary approval and appropriation. This is also indicated under Article 206(2) of the Constitution. Therefore, any expenditure that does not proceed on the basis of pre-approval by Parliament, my lady, is expenditure that is unconstitutional. Reading the Constitution purposively, in light of the goals behind the requirement for parliamentary pre-approval, should lead this court to the conclusion that the reason why parliamentary pre-approval is a precondition for expenditure is to ensure democratic control and democratic accountability of all public expenditure. In this particular case, my lady, it has not been contested that PPPs are actually an aspect of public expenditure. And I've already indicated to the court the various ways through which PPPs are aspects of public expenditure. And my lady, Council has mentioned Section 88 of the PPP Act as an illustration that indeed Parliament is involved in the pre-approval of PPPs. However, my lady, when you look at Article 88 of the PPP Act, 88.1 talks about the Directorate shall submit to the committee, that is the PPP committee, a report on the state of public-private partnerships in Kenya. It's a status report on PPPs in Kenya. And even that status report, my lady, under Section 88, the primary duty is for the Directorate to submit it to the committee, the executive, the PPP committee, which is established under the National Treasury. The primary duty is not to submit it to Parliament. Parliament is only mentioned as a secondary recipient under Section 88(3). And basically, it's just the status report. What we have a problem with, my lady, is provided for under Section 82 of the PPP Act, which is with respect to each and every PPP project, who monitors it, who oversees how it's being implemented, that indeed is being implemented according to the authority which was given by Parliament. My lady, this is made possible currently through Article 228 that requires the Controller of Budget to submit quarterly budget implementation reports to Parliament to facilitate the oversight of Parliament of the implementation of budgets. The PPP Act does not provide any role for the control of budget, which essentially means then that it takes away these quarterly budget implementation reports that the control of budget ought to submit to Parliament to facilitate its oversight role. Under Section 82, the project company is required to submit the project performance reports, monitoring reports, to the contracting authority and the directorate. The contracting authority is the state departments, agencies, and corporations. Nothing is mentioned about Parliament. My lady, with respect to the second issue on the applicability of the Public Procurement Asset Disposal Act, the question that is before this court is Article 227 has been submitted, establishes what my co-counsel mentions as threshold that ought to be made by all systems of procurement. Those thresholds are about transparency, equity, cost effectiveness. And what we are asking with respect to specifically the constitutionality of Section 4.2 of the Public Procurement, the Public-Private Partnerships Act, and the relevant provisions of the Public Procurement and Asset Disposal Act is the Public Procurement and Asset Disposal Act the primary legislation that has been enacted to give effect to Article 227? It is. And you will find this, my lady, in the long title of the Public Procurement and Asset Disposal Act, which states that this is an act of Parliament to give effect to Section 227 of the Constitution. And it has done that by providing under Section 3 a series of guiding principles, broad principles intended to achieve the goal of Article 227. Therefore, when you enact another legislation that then overthrows the applicability or ousts the applicability of the primary legislation intended to apply Article 227, in essence, what you're doing is you are ousting the applicability of Article 227 to that particular legislation. And that is our submission, my lady. That to the extent that the Public, Private and Partnership Act and the sections of the PPP, the Public Procurement and Asset Disposal Act, oust the applicability of the Public Procurement and Asset Disposal Act, they essentially are ousting the applicability of Article 227. My lady, it's been submitted that it's not clear as to what issue we have with the CS's involvement. We don't have a problem with the CS's involvement in the implementation of the Act. We only have one problem. My co-counsel has mentioned something called a Swiss challenge. My lady, a Swiss challenge in public-private partnerships is essentially what we are asking this court to mandate. A Swiss challenge is where if I come to a state department with a private proposal to upgrade JKI or to install electricity transmission line with Ketraco, then the public body is mandatorily required to submit that particular proposal to public competitive procurement. That is the Swiss challenge. A mandatory requirement to submit any privately initiated proposal to public procurement and market testing for purposes of assessing value for money. Under the current PPP regime, specifically sections 44.5 and 44.6, there's no Swiss challenge, mandatory Swiss challenge there. What is there is a discretionary Swiss challenge. And our problem with this discretionary Swiss challenge is the discretionary aspect. We are not contesting whether the PPP Act has a competitive model of procurement. Actually, Section 37 has 4 procurement methods: competitive, privately initiated proposals, direct procurement, and restricted bidding. We don't have any issue with them. What we have specifically is that discretion exercised by the CS that is unfettered, in such a way that the unfettered aspect then obscures transparency that is required under Article 227, obscure the cost discovery, market testing and cost discovery, and therefore undermines the cost effectiveness that is required under Article 227. They have not submitted that there is any way that the Act requires mandatorily the CS to submit privately initiated proposals to mandatory market testing and price discovery. It will be submitted, my lady, that Parliament has a role under Section 63 of the Public Procurement and Asset, the PPP Act. Indeed, Section 63 is the only section in the entire Act that allows Parliament to pre-approve or to ratify, which is post entering into project agreements, which essentially is unconstitutional because Parliament's role is pre-approved. So Section 63, however, is restricted, my lady, to only those project agreements touching on natural resources. That is the only role that is given to Parliament, ratifying after the fact project agreements only touching on natural resources. The Constitution does not restrict Parliament's role insofar as pre-approval of public expenditure is concerned. It requires pre-approval of Parliament with respect to every aspect of public expenditure. And therefore, our argument, my lady, is that the fact that all other project agreements touching on all aspects of infrastructure, whether it's in the water sector or the energy sector or the road sector, all those ones that don't touch on natural resources, the fact that the Act gives that power to the PPP committee, which is established under the National Treasury, it usurps the pre-approval role of Parliament. My lady, with respect to the issue of the retroactive application of the Act, it's been submitted, my lady, that there are private rights that have already been acquired. And in a sense, therefore, there's a legitimate expectation that these private rights are going to be implemented. My lady, it's clear and tried law that there cannot be legitimate expectations where, insofar as constitutionality is concerned. And our concern, my lady, is that while indeed, yes, we agree that a declaration of unconstitutionality that applies retroactively will necessitate the renegotiation of this project agreement with the scrutiny of Parliament to ensure constitutionality, my lady, we hold that this is a fair and a just and a proportionate way to ensure that the long-term effects of these 20-30-year multi-billion projects and the repayment burdens that are perpetually imposed on not only the current generation, but multiple generations, the imperative under Article 201C for intergenerational equity, and the imperative under Article 10(2)D on sustainable development, there is no way we can guarantee sustainable development if we do not assess and audit all PPP projects to ensure that the debts and the contingent liabilities that have been acquired by Kenya under them are sustainable. Therefore, if we only declare unconstitutionality and require that applies prospectively, we will be constitutionalizing all the 41 multi-billion, multi-year projects that have been signed and entered into contrary to the Constitution. My lady, our submission is that the public interest, and my lady, this a preponderance of jurisprudence, that public interest lies in the upholding of Constitution, of the Constitution and constitutional order. And we believe, my lady, in this particular case, public interest lies in a retroactive application of your order of unconstitutional, or your finding of unconstitutionality, and retaining jurisdiction to give the respondents an opportunity to be able to ensure, go back and ensure and report what measures they have undertaken to bring all those 41 PPP projects in compliance with the Constitution. My lady, with that, we rest the petitioner's case.